Everybody is seeing my PPT. Can anyone please confirm?
No, no, sir.
Oh, I see.
It is visible.
I
Yes,
see.
it's visible.
Sorry, Thiagu, can you please check your side actually?
Illa, sir, no, it is not visible.
Thiagu, can you please connect once after logging it once again? Because I think there would be the net issue at your side.
No, it
Because
is not in presentation mode, but
yeah.
it is visible.
Oh, I see. How is it now?
You can change the slide, then we can.
Hmm.
Yeah, it is visible, but
Sir, now it is okay.
Okay.
it was the same earlier.
Okay. Good evening, friends. Today we are going to see about the writ jurisdiction under the High Court and Supreme Court and labor laws. Uh, Actually, we are all knows that there are some of the reliefs which we can obtain from the that is High Court and the Supreme Court when we have deprived under the fundamental right as well as the some of the rights which are not emphasized under the law. So normally all the people doesn't go to the High Court or Supreme Court because some of the cases in like ESI, PF and other some of the act which has got the appellate tribunal, then only we can knock the doors of High Court and Supreme Court. But in many of the nowadays, in many of the cases, during the pandemic period, also for the payment of wages during the time of pandemic and other thing, the media person has gone to the Supreme Court, and the Supreme Court has given the direction by bypassing the order given by the Ministry of Labor, because the Ministry of Labor asked to restrain from the payment of wages, but the Supreme Court asked the Ministry of Labor to give the direction to make the payment of wages under their writ jurisdiction. Like that, there are so many cases has been filed during that time, and in between that also there are many cases has been filed in the Supreme Court and High Court for payment of wages, termination of employment, recognition of union, and other issues also. Now we will see what is called the writ and how the labor laws which is applicable by the various case judgments and all. In India, Constitution has provided the Supreme Court with the power to issue the writ under the Article 32 when the person has deprived under the fundamental right. That power is vested with the Supreme Court. So we have got an enormous fundamental right. Whether we are having the fundamental right of labor laws like freedom of association, right to work, equality, condition of work, and living wage, payment of living wage, and Article 19, Article 23, Article 24, human traffic and the children's protection of children. Like that, there are various articles are available under the Constitution. Though there are so many rights which are available under the Constitution, those rights in some of the cases the court itself says that it doesn't mean that that is the fundamental right, but it is a statutory right, that is the rights given under the Constitution, but it will be reviewed when we knock the doors of High Court as well as the Supreme Court, because in some of the times the executive authority has not considered properly when in one case the tribunal has passed the award based upon the limitation, because in the closure of a company, the 90 day, if the 90 days has passed, then automatic things will happen. So in that case, the tribunal has denied to consider the closure application, and they have not intimated to the respective company. Subsequent to that, they filed the writ petition before the High Court, and they got a review. They got a review petition opportunity. Then they filed and they got the closure permission from the government, appropriate government. Like that, in many of the cases, the writ applications has been considered by the High Court and the Supreme Court. In some of the cases, the writ application has been denied because of there is no grounds at all. Like that also they have denied. But with coming to the Article 32, it clearly consider only on deprival of the fundamental rights. When now we are going to see what are all the writs which are available. That is relief available under the High Court and the Supreme Court. Number one is habeas corpus. That is for wrongful detention of a person without any and enforce the fundamental right of the individual liberty. When this writ is issued, a person or authority who has arrested another person has to bring that another person before the court. So the police authority has wrongful detained the person, and the affected person's either brother or sister or somebody in their family who has approached the court for wrongful detention. That is called, that writ is called habeas corpus. And rules for habeas corpus, the applicant should be in a custody of other. Family members can file an application, or a stranger can also file an application in the public interest. Formal or informal application can be filed. Same application cannot be made successfully to different judges of the same court. And the rules for habeas corpus, all the part of formalities and the procedures should not be followed by police while making an arrest. Example, Himesh was making a threat to Hina. So father of Hina, who is a police officer, arrested the Himesh and imprisoned him. Here, the police officer has arrested the Himesh, and police officer Hina's father didn't file the FIR and did not follow the procedure to arrest the Himesh. So Himesh wrongfully detained. Kirtik, who is the brother of Himesh, filed an application in the respective court, and by issuing the writ of habeas, his detention has been overruled. Like that, the habeas corpus can apply by way of applying the writ in the High Court. Sorry. Literal meaning of mandamus is we command. This is the another way of one writ. This type of writ is used when a public official or public body or corporation or the lower court or the tribunal or even the government has not done their duty or refused to do so. In some of the cases, the registering authority is not issuing the birth or death certificate, or police is not giving the report, mortuary report, or police is not doing the things, whatever the like FIR or something like that, as well as the tribunal is not asking for documents, and they are going beyond their purview. Like that, in the labor tribunal also, some of the occasions, tribunal will ask so many documentary evidences and all, but they doesn't have the authority to so many review the things and all. In those occasions, the writ petition can be filed by the respective people, and they can get the relief by way of applying the writ of mandamus. Grounds for mandamus: petitioner must have the right recognized by the law. Infringement of the right must be done. Actually, infringement means they decline the permission or decline the benefit by the respective authority. I am the citizen of, say for example, I am the citizen of India. I have to get the education, I have to get the birth certificate, I have to get the author, I have to get everything under the law which provides, law of the land. If I am denied, this writ will apply, and we can get the relief by way of getting the writ permission from the High Court. Petitioner must demand the authority to perform the duty, and non-performance of the duty must be present. Other remedy must be absent. There is no remedy at all for a person. He can approach the High Court and get the by way of applying the writ of mandamus and get the relief from this writ petition. And non-performed duty must be mandatory duty. So, if I am a citizen of India, I have to get the education. That is a rights given under the law. So, if I am denied by the education and other thing, that is called the non-performed duty of the government. that is executive authority. So the High Court will get the relief by way of issuing the writ of mandamus, and that is the duty of the person. They will ask the authority to do that. Like that, here one case, a person has approached the electricity board for electricity connection, and the director has denied the give the electricity connection for that house. So she approached the court, and they got the relief from the government by way of applying the writ of mandamus. And next writ is writ of prohibition. Literal meaning is prohibition is to forbid. This writ is given to the lower court which exceeds its jurisdiction and unpursue a jurisdiction which is not possessed by it. Here, the writ of prohibition will apply when court is not hearing anything, or they go beyond whatever the jurisdiction is given by the higher court. Those times we can approach the High Court and get the writ of prohibition and get the relief by way of applying this writ. What are all the rules to be followed while applying this writ? Lower court or tribunal should be overstep its jurisdiction. So these are all the grounds should be there. Otherwise, the High Court will not entertain writ of prohibition. Lower court or tribunal goes against the law. If the lower court or tribunal partly acting in jurisdiction and the partly outside the jurisdiction, so the lower court is going beyond, or they are going outside the jurisdiction, prohibition will be issued against the act which is partly outside the jurisdiction. Proceeding must be pending before in the lower court or tribunal. Here, in some of the occasions, the lower court will hear the things, or tribunal will hear the things. Those times the higher court will oversee the things and entertain the petition given by either by the petitioner or by the applicant. Those times also this writ of prohibition can be filed before the High Court to stop those proceedings in the higher court. That is also available under the application of this writ of prohibition. Application should be made against the judicial or quasi-judicial body only. Here, the judicial or quasi-judicial writ of prohibition can be only be filed in this writ of prohibition. And next thing is certiorari. Here, certiorari means to be certified, to be informed. This type of writ is used to transfer the case which is pending in the lower court, or the order given by the lower court in case of need to be quashed, because they doesn't have the jurisdiction, but they are doing they are entertaining those cases that time also, and that court, the higher court doesn't felt that the lower court is not exercising its authority properly. That time also this writ will apply. This writ will issued on the basis of excess jurisdiction or lack of jurisdiction or error of law. During that time, we can move a petition before the High Court by way of applying this writ of certiorari. And the grounds for writ of certiorari: overstepping or abuse or absence of jurisdiction should be present by the lower court. Violation of principles of natural justice can be present. Some error of law can be present. And condition of certiorari: the body of person should have the legal authority, and authority should be related to question affecting the rights of the people. Body or person has the duty to act judicial while functioning. Person or body has acted in excess of their jurisdiction or legal authority. So these are all the grounds should be there while we are moving the petition in the way of instituting the writ of certiorari. Then next writ is quo warranto. This is called by way of what authority or warrant. This is the type of writ which is used when illegal observation of a public office by a person is done. After this writ is issued, the legality of the claim of a person to the office is inquired. See, in some of the cases, the officer doesn't have the authority. Say, for example, in case of the collector is directly coming for an inspection, while we are letting out the effluent treatment into the common drainage. Say, for example, the appropriate authority first is the local authority, that is Panchayat, or the pollution control board. But by overriding these things and all, or by the, say for example, revenue officer is coming and they are inspecting the sewage of water letting out into the common streams. At that time, we can apply this writ of quo warranto and get the relief from the High Court. Here, the conditions of quo warranto: office which is wrongfully assumed by the private person should be a public office. Office should be created by the constitution or other statute. Duties of the office should be public duties. We cannot file this writ against any duties of the private person. Office should be a permanent. Application should be made against a person who is a possession of such office and uses the office. Office should not be in a private nature. We cannot move a petition against the private parties. This writ can be instituted against the public office. Here one example. Sanjana is a private citizen. She doesn't have any qualification at all, but she has been posted as a RTO officer. Although assume such office. Here, writ of quo warranto can be issued against Sanjana to call into a question her authority on which she has taken the control of the RTO officer. So these are all the writs which are available in the provision of High Court, and we can move the writ petition before the Supreme Court under Article 32 whenever our fundamental rights is deprived. During those time only we can approach the Supreme Court. Otherwise, the Supreme Court will not consider those things. We have to approach under Article 226, or we can approach by way of instituting all these 5 writs. Now we are going to see case by case under the labor laws. In the case of Bengal Chemical Pharmaceutical Works Limited versus their workmen, Supreme Court has laid down 3 grounds where the special leave petition can be filed for an industrial dispute, where the awards were made in violation of natural justice. Here we have to see it to that one side is considered during the time of award, or there is no opportunity has been given by the court, or whatever the documents and evidences produced by the petitioner or applicant that has not been considered by the respective court, those times we can approach the Supreme Court. In those cases which require explanation on the important principles of industrial laws and requires the final decision by the Supreme Court. Here, they are not going to see what are all the material fact which is inside the document or something. When the time of deprival of rights, fundamental rights, those time only the Supreme Court will knock their nose. That is very much cleared in the Bengal Chemical Pharmaceutical Works Limited versus their workmen. Any other exceptional special circumstances which merits the consideration of the Supreme Court. Here, we can see about our sterlite industries in Tuticorin. Here, the Vedanta group has made a plea to the Supreme Court. They are adhered to the standards. Their application has not been considered by the National Green Tribunal, State Green Tribunal, as well as by the state government, as well as by the many courts. So they approached the Supreme Court, but Supreme Court has denied when the things are out of the hand of public concern. So they denied to hear those petitions. That is one among the case. Additionally, in the case of management of Wagner versus their workmen, it was held that when the Supreme Court entertains an appeal pertaining to the Industrial Dispute Act, it does not act as a court of appeal of facts, but only can decide on the matter of law. They will guide and they will evolve their principles. So, the Supreme Court always decide the Industrial Dispute Act based upon if any matter of law is lacking, or guidance is lacking, or principles are not evolved in the act. In those cases only, Supreme Court will hear the things under the Industry Dispute Act. In the case of United Bank of India versus Bachchan Prasad law, a punishment has been given by the tribunal in the case of Bank of India, and the employee has joined in the year 1973 and having the grievous misconduct and suspended. Subsequently, he has been dismissed because of he has not appeared before the inquiry. So, ex parte award has given. Then he has been subsequently terminated. Then he is made on appeal. That matter went to the tribunal, and appeal also rejected by the court and the tribunal. Then he invoked the section 11A, and the tribunal observed that punishment is inappropriate and order for lower rank and no wage for suspension period. The court is entertained, the tribunal has entertained under section 11A of Industrial Dispute Act and given the order for lower rank and no wage for suspension period. Then the Bank of India made an appeal before the Division Bench of Patna High Court and upheld the tribunal award. The Patna High Court also upheld the tribunal award. Subsequent to that, the Bank of India went to the Supreme Court, and the Supreme Court observed that dismissal of an employee is proportionate and to be reviewed. So here, dismissal of the employee is disproportionate. Sorry, here there is a typographical error. Disproportionate, and ask the tribunal and the High Court to review the things. So here the Supreme Court will see to that the matter of material fact and the principles and the guidelines given in the ID Act. They never see what are all the sections, whether right or wrong, those things, they will not consider those things. And next we are coming to the another case, CCRAS case. Here, a Department of Health, they engaged the people under the Ayush program, and another people has applied in the general category. After the retirement, some people are observed into the roles based upon their skill set. But in Ayush, that is the different GO, the Ayush is framed under the different skill set. Here, the person has retired and he has asked for the extension. The researcher made an appeal and the direction of extension by instituting the right. He has filed the writ because his petition his application has not been considered in the post-retirement case. But he asked the Ayush, but Ayush has denied. Subsequent to that, he filed the writ petition, but the SC pulled the HC because the High Court has given the direction to consider his case, and the Ayush has filed the writ petition before the Supreme Court, and the Supreme Court said that Article 39D of the Constitution provides for the principles for equal pay for equal work and equal value. This principle was first considered in 1962 in the case of Kishore Mohanlal Bakshi versus Union of India. Supreme Court subsequently ruled that it could not be enforced in the court. So Supreme Court clearly said that this should not be considered by the court. The High Court has been condemned by the Supreme Court in this case. In the case of Bengal Chemical versus Pharmaceutical India, this we have already seen. In the case of Hari Vishnu Kamath versus Ahmad Ishaq, it is held that High Court, while issuing the writ of certiorari under the Article 226 of the Constitution, can only annul a decision of the tribunal, whereas under Article 227 of the Constitution, it can be issued a further direction as well. Here, under the Article 226, High Court can entertain the petition for under the writ of certiorari, but in the case of Article 227, they have to approach the lower court, and if the lower court we could not get the benefit or we cannot get the relief, then only we can approach the High Court by way of instituting the writ of certiorari under Article 226. As noted above, prayer in the writ petition was set aside the decision of the Labour Court. In the case of PTA employees case in the Delhi High Court, 297 employees retrenched with getting government permission, but contract workers were retained. In this case, about 297 employees were retrenched. Press Club of India case. So they retained the role employees whoever joined earlier, but they retained the contract workers who have joined the recently. Then the case has went to the court, that is conciliation officer first. Then that matter went to the labor court as well as the tribunal, and they have all considered that the retrenchment is upheld. So subsequent to that, the PTA employees has filed the petition before the High Court. Then the High Court said that no last come first to go has adopted. Trade union filed the writ petition. HC observed that this is not an exceptional circumstances. In this case, the PTA said that this is an exceptional circumstances. This case was held during the time of COVID. So we terminated the employees during the exceptional circumstances. Under the ID Act, it says that when we terminate on employees under these exceptional circumstances, there are some grounds should be there. But in this case, the exceptional circumstances has not been considered by the High Court. The remedy is available through the tribunal, they said. Ask the tribunal to settle and submit the synopsis by union. Treat this as a exceptional circumstances. Here, the High Court has asked the tribunal review the petition once again, whether it has come in full shape or not. Because here, the last come first to go under the retrenchment, under the provision of Industrial Dispute Act has not been applied. So it has been sent to the tribunal once again and review the petition by the PTA employees. In the case of State of Punjab and others versus Jagadish Singh, temporary workers denied the wage at par with the permanent workers. The Supreme Court observed that should not deny if the qualification and the merit matches to the with the permanent. Say here, there are temporary workers were engaged in along with the permanent workers, but the temporary workers were denied the wage at par with the permanent workers. So they filed the petition before the court, and the Supreme Court observed that we should not deny their plea. We have to see to that the qualification and the merits of the temporary people at par with the permanent. If it is there, we have to pay the scale pay to the permanent or at par with the permanent workers. The scale pay start with the beginners level. Here they clearly said that it should be start with the beginners level. Say for example, I am in the experience of 15 years. I am the permanent employee. If someone is meeting with my qualification and experience, but his experience is just 5 years, means whoever in the 5 years of experience, their wage should be fixed for that person. That is the judgment given in the case of State of Punjab and others versus Jagadish Singh. In the case of Sabhasankar Dubey versus Divisional Forest Officer, in this case, temporary workers denied the equal wage at UP Forest Department. They filed the petition before the High Court and asked to pay the minimum pay scale. But the Allahabad High Court reversed the petition and not to pay the minimum scale pay. Then they filed the writ petition before the Supreme Court, and the Supreme Court ordered to pay minimum scale of pay. Here, they asked to pay the minimum. Before the earlier case also, the Supreme Court said that the Punjab High Court said that we have to pay the minimum scale of pay in the beginners level. In this case also, the Supreme Court said that minimum scale up to be fixed whoever meet to the age and the qualification of the temporary workers. We have seen this case. And Tech Mahindra case, filed a writ petition by the Tech Mahindra for payment of bonus on retrospective. This is a recent case after 2020, reviewed by the SC, because in many of the cases, the GO has come from the Ministry of Labor later, but all the companies has reviewed their financial statements like balance sheet and all. Subsequent to that, they have paid the payment of bonus during that time. At that time, The workers union has filed the petition before the court. Their payment of that is calculation of bonus should be based upon the either by the minimum wage or the government fixed under the rate of rupees minimum of 7,000. The Tech Mahindra people has got the 7,000 rupees minimum scale of pay, but the court has given if it is more than minimum wage, the minimum wage has to be considered. But the Tech Mahindra has denied. Consider the plea. Stated is cumbersome to assess the back work. The Supreme Court also considered that after the so much of a period, the retrospective effect cannot be considered. So agreed to pay the whatever the old GO, you can based upon that you can make the payment of bonus for the Tech Mahindra case. This case is famous case delivered by the Supreme Court under the Payment of Bonus Act. In the case of Rajasthan Transport Corporation versus Workmen, conductor has not issued the ticket and found guilty and he has been terminated and filed the petition before the labor court and confirmed the order. Then he filed the petition before the High Court and the High Court ordered to reinstate with the back wages. The Rajasthan Transport Corporation filed the review petition before the High Court and the High Court single bench declined the High Court order and asked to pay the 50% wage from the date of termination till his death. Then High Court asked the Rajasthan, that is High Court, to review that petition. Then the review petition has been filed by the Rajasthan Transport Corporation. That matter has been reviewed once again, and the reinstatement should be denied. And the person who has terminated maintain the same status quo, and his termination is. They said that the termination is legal, even after the termination has been upheld by the High Court. The Rajasthan High Court, Rajasthan Transport Corporation has made a writ petition before the single bench of Rajasthan High Court, and they got the order of termination is valid in this case. In the case of Manu Mohit Industries versus State of Jammu Kashmir and others, workers terminated for non-performing duty and raised the dispute under Section 10 of ID Act. Tribunal award for 1 lakh compensation. In this case, the workers were terminated under Section 10 of ID Act and the tribunal award for 1 lakh compensation. Petitioners challenged the award in the court of under the Article 226. High Court rejected the plea by saying that salary component and eligibility of the petitioner as a workman in terms of Section 2S of the Industrial Dispute Act. By invoking this section, they denied the petition. In the case of Security and Printing Minuting Corporation versus employees, here this Security and Printing Minting Corporation is owned by the public sector undertaking. They asked for the overtime working, and they approached the corporation, and the corporation denied, and they raised the dispute before the tribunal, claiming under the Factories Act. And the tribunal asked the corporation to pay the OT. Then they mailed the appeal to the High Court, and the High Court observed that benefits are extended by the government for PSUs clearly defined in their pay scales, and they have got the commission for making the payment for salary and other benefits. This the act of the Industrial Dispute Act, the Factories Act is meant for private sector. Those sections will not apply for the public sector undertaking. That is the judgment delivered by the High Court in the case of Security and Printing Minting Corporation versus employees, and the own rules for their payment and benefits that will be followed by the Security and Printing Minting Corporation. That was the judgment delivered in this case, and they asked to approach the appropriate forum. In the case of appeal time extension under the Section 7A of EPO on special circumstances, here the The PF authority has scrutinized the document. Subsequent to that, they asked to pay the amount, and the company could not able to pay the amount, and they could not able to file the appeal before the appellate tribunal in the provident fund, and the limitation period has gone. So the authority under the EPF asked for the claim the damages and all. Then they moved the petition before the court, and they got the relief from the high court in this case, Sudhakaran versus something, and in the year 2020 in the Madras High Court. This is a famous judgment. Writ jurisdiction on ESI default case by an employer. Petitioner running a firm and made a loss of 10 years. The petitioner company has made a loss year by year for 10 years. And assessment done and order issued under section 45 of the ESI Act. In the meantime, one of the partner filed a writ seeking the squash the order because they doesn't have the profit on year for the last 10 years. So they could not able to make the ESI contribution for their employees. So they filed the writ petition before the High Court to squash the order by the ESI authority. Here, writ jurisdiction under the ESI default is by an employer. As we observed that there is no reason to restrict and ask to approach the ESI court. Here, the court clearly said that, Supreme Court clearly said that they have to approach the ESI appellate tribunal, not by the court or the other thing, by way of instituting the, because the appropriate forum under the each act is very much available. If you take the PF Act, the appellate tribunal is there. In the way of ESI, the ESI appellate tribunal is there. And under the Industrial Dispute Act, the Labor Court and the tribunal is there. So the Supreme Court never accept these type of writs, and they denied under this case, and approach under section 75 of the Act with the documents and evidence record the closure due to loss. Here, they said that they could not able to remit because of they made a loss, but asked the company to approach under the section 75 of the Act of ESI with the documents and the evidences regarding the closure due to loss. They themselves given the direction by this way. And refer to case laws, the court relied on the judgment Willful Corporation versus Register and observed that alternate statutory remedy is not a constitutional bar to the High Court jurisdiction under Article 226 of the Constitution of India in at least three contingencies, where the writ petition seek enforcement of any fundamental rights, where there is a violation of principles of natural justice, where the order or the proceedings are wholly or without jurisdiction or ultra vires of the act is challenged. In these cases only, the Supreme Court always entertained the cases under the labor laws. That is very much a famous case, Willful Corporation versus Registrar of Trademarks. In the Manali petrochemical case, complaint registered against the company for unsafe conditions prevails by the trade union. 5 cases booked against the employer and 2 with the fine disposed by the factory inspectorate case. MPC has filed a writ petition for not to take action. Court observed that this is prejudice because here there is no case has been filed against the occupier. Before that, they filed the writ petition. So the court observed this is the prejudice and bias against the factory inspectorate. So they felt that this is the writ of prejudice. So the SOCAS issued after the inspection by the inspector, then this and taken under the case. So dismissed the Manali petrochemical case based upon the prejudice and all. So before inspecting by the factory inspectorate, they moved the file before the by the way of writ before the High Court. So they dismissed this case by way of considering that is under the prejudice and bias. In the Sarmika Kutir Udayo case, the company imputed for inspection and SOCAS to remit X amount. The company went for an appeal by writ, and the tribunal rejected the EPO stand and asked not to remit 75% of the pre-deposit for hearing. EPO opposed and said that the tribunal has not adherence with the section 7.0 of the reasons for full waiver. Here, the EPFO has given some EPO has given the direction to the company to remit the amount after the inspection, and if the company wants to go for an appeal, they have to make some X amount of money as a deposit, caution deposit, before the appellate tribunal, and before that, in between the time that moved the petition before the EPF appellate tribunal for full waiver, the tribunal also heard and delivered the judgment to remit the 75% of the pre-deposit for hearing. But the EPO opposed this and said that the tribunal has not adherence with the section 7 of the reasons for full waiver. The tribunal also asked why waited for 3 years after writ filed before the respondent now questioning for full waiver. So petition dismissed. In this case, the EPFO has not moved the petition in time under section a respective section. So the court, the EPF the appellate tribunal has not come up with the petition before within the limitation period. So they rejected the plea by the EPFO, and full waiver petition has been allowed, and the EPO petition has been denied under the Sarmika Kutir Udyog case. In the case of SAIL versus National Union Waterfront Workers, the state government made a GO for not engaging contract workers. The contract worker asked the observation in the SAIL. SAIL denied and filed the petition before the tribunal. The appropriate government. The SAIL denied and filed the petition before the tribunal. The appropriate government raised the dispute. The writ filed to settle who is the appropriate government. The Apex Court decided the central government is the appropriate government. In this case, the government itself, the SAIL itself has filed the petition before the Calcutta High Court, not with the respective court, and for getting the relief under the Contract Labor and Obligation Act. In this case, the appropriate government is central government, because this is coming under the public sector undertaking. So the Supreme Court said that you have to approach the appropriate government, that is the central government, not with the state government. This is the one famous judgment of SAIL versus National Union Waterfront Workers for under the Contract Labor Act. Workman of Firestone Tires versus management. Workman terminated, section 11 inserted at that time. The workman made a claim for reinstatement under section 11A, and the tribunal rejected, reviewed by the Apex Court and not considered, because during that time only under section 11A inserted under the Industrial Dispute Act. Before that itself, the termination has happened. So the court said that before it he has been terminated earlier, the act, the section inserted later. So his petition would not be considered under the case of Firestone Tire versus management. In the case of Bata Shoe Company Limited versus Gankuli, signed the wage settlement and later went on strike, terminated the workers who went on strike. Matter went to the conciliation. Both the parties arrived for settlement without conciliation officer. The court observed that this is void because conciliation officer absent for second agreement. Here, the wage settlement signed, actually they made the settlement under section 12.3, but without having the signature of the conciliation officer, they signed the wage settlement. Some of the workers went on strike. Subsequent to that, because they went on strike because of not agreeing with the wage and all. Then the matter went to the conciliation. In this case, the court said that if it is a 12.3, the conciliation officer signature is must. That is pronounced by the High Court. In the case of Bata Shoe Company Limited versus D.N. Kanguli. In the case of contract workers and perennial engagement, the issue of work of a perennial nature or violation of other provisions of contract labor has to be raised only through the industrial dispute and not under writ jurisdiction. Here, one company has directly filed the writ jurisdiction without knocking the door of appropriate government. The writ is denied by the court. In the case of unfair labor practice under ID Act, Bhatia General Hospital and other, Hanumantarao Raje and others, the union raised the dispute under Article 226 for management in indulging unfair labor practice. The management promoted the employees and extended the benefits. Here, in some of the companies, I have also noticed, because of people should not join under the union, they promote some of the people and given the decent increment at that time, and they promoted to the category of executive and all. In this case, the similar thing was happened. The company has promoted and they have been offered with a lump sum amount and promoted to the super rank and all. But the union raised the dispute by way of unfair labor practice. So, but the union said that the service condition and the subscription still goes. In this company, the members who has been promoted is remitting the subscription, and they are under the union settlement, and their service conditions has not been changed. They have not been given the appropriate appointment order and all. So this plea has been made by the union under the ID Act. The court cited from the judgment from IFCO Air India and IFCO judgment, as well as in the Air India judgment, and said that the nature of duty is important rather than designation change. This is the famous judgment, and all the companies who are in Chennai, they are following the some tactics to bring down the union membership by way of promoting the people to the next category. But whatever the duties they are performing, that is important rather than offering the ranks and the benefits will not sustain for making the sanctity in the legal side. Treated as a workman and observe this as a unfair labor practice. This is what the today's session's presentation. My presentation is over. If any queries, I will address. Yagu?
Yes, sir.
Any queries and all?
No, sir. From my side, no. Actually, this is an eye-opening session for many of us, including me. So, you have put a lot of effort to bring this case studies. Because normally, bringing the case study into the platform or picture, it is very difficult. So, really, you made a lot of effort to bring this. So, kudos to you, sir. Thank you so much for the wonderful presentation.
Yes. Thank you, Thiago, for your compliment. Yes, sir. Sridhar, sir. To me, sir.
Yes, sir. Sir, good evening, sir.
Good evening. Tell me, sir.
I got a small doubt, sir. I got
Yes,
a
sir.
small doubt in
Yes, sir.
ESA implementation, actually. Actually, ours is a company, we are doing the manufacture of web bridges, okay? And for installation of web bridges, we supposed to do some civil works, okay? For doing the civil works, actually, we are supplying the machines pan India, and for doing the civil works, we are engaging the contract laborers.
Yes, sir. Tell me, sir. Hello.
Good evening, Murali. ரொம்ப யூஸ்ஃபுல்லா இருந்தது. செஷன் வாஸ் வெரி யூஸ்ஃபுல். டாடா.
Hello.
Yes, sir. Your voice disconnected, sir. In that meantime, Mr.
Yes, sir.
Yes, sir. Tell me,
Okay,
sir.
well, so we are engaging contract workers, civil workers, for doing the civil work. Okay. Normally, the civil work is taken place for around 3 to 4 days only. Okay. So normally, civil workers are all in migration in nature. They are not stick to one place. Okay.
Yes.
So they don't have any permanent ESI number or permanent bank account, other things. Okay.
Yes.
For extending the ESI benefit, we require their bank account and their PAN card and other details. Okay, for registering the member under the ESI. Okay. So it is very difficult to include them in the ESI. So what we decided, no, whatever the bill amount they are charged. Okay. So we suppose if they charge around 20,000 for the particular civil work, some portion will be taken as a wages. Then the ESI amount deducted on a flat rate. Okay.
Hmm.
So then we are remitted the contribution.
Okay.
But we are unable to furnish the details.
Hmm.
Who
Yes.
are all the beneficiary? We are unable to
Yes.
furnish the details.
Yes. Yes. Yes.
So now ESA is asking for the details.
Hmm.
So in that case, how we supposed to go, sir?
Yes, sir. That is mandatory under the ESI Act. Actually,
Yes,
in
sir.
many recently, I come across with one case law I studied actually recently.
Yes, sir.
So whatever the contribution you are remitting, you have to mention the subscriber's name and other details.
Yes,
That
sir.
is mandatory.
Yes, sir.
Yeah.
Because
Actually, apart.
for the people are in migration nature, so they are not strict to one company, no.
Yes.
So in
I
that
agree
case,
with you.
how we can enroll them, how we
Yeah.
can
Yeah.
extend the benefits.
Yes, sir. Apart from this legal side, I can say to that in many of the companies they are following that they are insuring those people under public personal accident insurance act, because I read one judgment that those who are coming under the intermittent nature, not in interval nature, intermittent nature, whatever the case
Okay.
you said. So we can apply those things, that is personal accident insurance and other. Ultimately,
Yes,
what
sir.
we should do, we have to compensate when the time of partial or the permanent, or in the case of death, fatal cases, we have to compensate, right, sir, for
Yes, sir.
their
Yes, sir.
life.
Yes, sir.
So we
Yes, sir.
can do that one. No one will question. This is apart from my this session and legal side, I am saying. Okay.
Okay. Okay.
You text me. You note on my number. I will text in
Yes, sir.
the call box. You
Yes,
call
sir.
me and I will give you the guidance. Okay, that is
Okay. Okay. Okay.
not at par with the law, but
Uh,
I will tell you the things and
uh,
all. Okay, sir. You.
Actually, because of the pathetic nature, no, the PSA authorities has got a powers.
Hmm.
So they simply, what I'm going to say, without going into the subject, they
Hmm.
simply send the notice. Actually, they
Hmm.
simply send notice to the managing director.
Okay.
So you are
Okay.
not furnishing the details. You are remitting the contribution on time, but you are not
Hmm.
furnishing the details. So it is an
Yes, sir.
offense under the EXA Act. So,
But
so you are punishable under the Act.
no, sir. We can get a relief from some other way. I will tell you
Uh,
informally, sir.
okay, sir. Okay, okay.
Okay, sir.
Thank
Okay.
you, sir. Thank
Sir,
you, sir.
Okay.
sir, good evening, sir. Shivaram here. Is
Yes,
there
sir.
any
Sure, sir.
is there any classification like state government court and central government court? Because you said with respect to the Salem steel plant, steel
Appropriate
authority.
government, sir. See, in that case, the public sector undertaking will fall under the central government purview, right, sir?
Oh,
So,
sir.
steel authority will come under the PSU
Public sector.
actually.
Correct.
So, the central government is the appropriate authority, and in some of the scheduled employment, which are all come under the central sphere, that will not
Yeah.
come under the state sphere. When they are
Okay.
signing the wage settlement, say for example, it's only an example, like
Yeah.
cement industry, which are far under the central government
Correct.
sphere, or Bharat heavy electricals, or some
Hmm.
of the companies which are all come under the central purview. So
Correct.
the central labor commissioner and the central labor tribunal is the appropriate authority, not the state
Okay. Okay.
authority. In that case, the authority filed the writ petition before the West Bengal government. Actually, they have to file the petition before the central government. That is before the Supreme Court. That was the judgment in the sale, sir. Sale case. Okay,
Okay.
sir.
There was a break, sir. Can you come again, sir? That point it was there was a break in the
Oh, I
voice.
see. Okay. In the sale
Appropriate.
case, yeah, in the sale case, what has happened? They terminated some contract workers. Actually, the contract workers filed the petition before the labor tribunal under the West Bengal government, and the West Bengal
Yes, sir.
labor tribunal asked for the reinstatement. Then the company sale has filed a petition before the High Court of West Bengal, asked to squash the order of labor tribunal. Then the High Court said
Okay.
that this will not come under our purview; it will come under the central purview, central sphere. That
Okay.
is the
Mm.
thing, sir. That is the order given by the High Court of West Bengal under the sale
Okay, sir.
case. Okay, sir.
Yeah. Understood. Actually,
Okay.
I had with this I just had a doubt whether there is any state government court or central government court. That
Okay.
is all.
Okay.
Understood. Understood. Thank you, sir.
Thank you.
Sir,
Any other?
good evening.
சார் உங்க இதை நான் தெரியாம எடுத்துட்டேன் சார், மன்னிச்சுங்க.
அதெல்லாம் ஒண்ணும் இல்லை சார். சார் எவ்ரிபடி ஹேஸ் தேர் ஓன் ஸ்பேஸ் சார். அவங்களுக்குன்னு ஒரு ஏரியா இருக்கு சார். ஸோ யூ ஹவ் கிவன் மோர் இன்புட் சார். அது வந்து டெஃபினெட்லி யூ டிட் யுவர் ஹோம்ஒர்க் அண்ட் யூ ஆர் கிவிங் மோர் வேலிட் இன்புட் சார். இந்த அப்ராப்ரியேட் கவர்மெண்ட் இஸ் ஆல்வேஸ் இது சார். நானும் ஆனந்தன் சார் நிறைய டிஸ்கஸ் பண்ணிருக்காரு ரீசெண்டா. ஆனந்தன் சார் இருக்காரா லைன்ல?
அவர் ஹீஸ் இன் த டிராவல் சார்.
ஆமா, மதுரைக்கு போறேன்னு சொன்னாரு. பட் லைன்ல இருக்காரான்னு தெரியல. ஏன்னா நானுமே இப்போ இங்க ஜெயச்சந்திரன்ல இருக்கேன். பட் இருந்தாலும் லேட்டா ஜாயின் பண்ணாலும் லேட்டஸ்டா வந்துருந்தேன்னு அட்லீஸ்ட் ஒரு 10 minutes லேட் ஆயிடுச்சு. ஹெட்போன் இல்ல, என் பொண்ணு எடுத்துட்டு சொல்லி ஜாயின் பண்ணேன்.
ஓகே சார்.
இப்ப என்னன்னா இந்த அப்ராப்ரியேட் கவர்மெண்ட் அது வந்து எப்பயுமே தெர் இஸ் a இஷ்யூ சார். பிகாஸ் அதை வந்து டிசைட் பண்றது 2-3 ஃபேக்டர் இருக்கு சார். ஒன்னு இண்டஸ்ட்ரி.
Yes, sir.
If the industry falls in the purview, somebody has raised the query. That's why I am addressing on my part. Can I go ahead?
Yes, sir. Yes, sir. You can.
Yeah. அதுல என்னன்னா சார், அப்ராப்ரியேட் கவர்மெண்ட் டிசைட் பண்றது 3 ஃபேக்டர் சார். ஒன்னு இண்டஸ்ட்ரி. If it is an airway, railway and waterways. இந்த மூணும் comes under the purview of central government.
Central sphere, yes.
So central sphere-ல இருக்கும்போது it is an appropriate government, even it is a private company, whatever it is.
Yes, sir.
Again, another factor is the holding pattern.
Yes.
Holding pattern of the organization. If it is a 51% holding by the central government, it is a appropriate government is central government.
Yes, sir.
Then again another waterways.
Yes, sir.
Waterways are also controlled by central government. Again, whatever sphere of organization comes under the waterways falls under the appropriate government.
Yes, sir.
இந்த 3 பேட்டர்ன் மட்டும் தான் டு டிசைட் அப்பான் தி ஸ்பியர் ஆஃப் அப்ராப்ரியேட் கவர்மெண்ட்.
Yes, sir.
இதுல ஒரு 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 வினோதமான ஒரு சில ஆர்கனைசேஷன்ஸ் இருக்கு இப்போ ரீசெண்டா. 50% ஹோல்டிங் பை ஸ்டேட் கவர்மெண்ட், 50% பை சென்ட்ரல் கவர்மெண்ட். ஒரு 2 ஆர்கனைசேஷன் சென்ட்ரல் பப்ளிக் செக்டார், 2 ஆர்கனைசேஷன் ஸ்டேட் பப்ளிக் செக்டார். ஹோல்டிங் பேட்டர்ன்ல 50-50 ஈக்குவலா இருக்கும். லைக் மெட்ரோ ரயில். பிகாஸ் ஐ வாஸ் பார்ட் ஆஃப் மெட்ரோ ரயில். டிஸ்பியூட் இஸ் ஸ்டில் பெண்டிங் வித் ஹை கோர்ட். இதே மெட்ரோ ரயில், டெல்லி மெட்ரோ ரயில், ஹைகோர்ட் ஆஃப் டெல்லி said it is central because Delhi metro rail belongs to union government. Union is part of central government. So union government of Delhi and the government of India both are central governments. So அதனால அவங்க சொல்லிட்டாங்க. பட் ஸ்டேட் கவர்மெண்ட்ஸ்லாம் கர்நாடகா ஸ்டேட் கவர்மெண்ட், கேரளா ஸ்டேட் கவர்மெண்ட், தமிழ்நாடு ஸ்டேட் கவர்மெண்ட்ஸ்லாம் 50% ஹோல்டிங் இருக்கும்போது who is the appropriate government is still at question. For the purpose of operational difficulties to redress the issue, time being வந்து சென்னை ஹைகோர்ட் has said ஆபரேஷனலா நீங்க லைசன்சஸ்லாம் வந்து ஸ்டேட் கவர்மெண்ட்ல வாங்கிக்கலாம் லேபர்ல அப்படின்னு சொல்லியிருக்காங்க. சோ நீங்க இப்ப இந்த செயல் கேஸ் சொல்லும் போது இந்த மாதிரி இஷ்யூஸ் வரும்போது இங்க வந்து இந்த ஹோல்டிங் பேட்டர்னை வச்சு இல்ல ரயில்வேன்னு சொன்னா மெட்ரோ ரயில் இஸ் நாட் அ ரயில்வே. அது ரயில்வே ஆக்ட்லயே வராது. ஏன்னா அந்த ஹோல்டிங் வந்து பை Ministry of Urban Development.
Yes, sir. Evolved under separate entity.
Though they are railway operation தான், but railway act கீழ வர மாட்டாங்க.
Yes.
So அதனால வந்து இந்த டிஸ்பியூட்லாம் இந்த அப்ரோப்ரியேட் கவர்மெண்ட் இன்னும் கூட டிஃபரெண்டான காம்பினேஷன்ல வந்து நிறைய ப்ராப்ளம்ஸ் வர்றதுக்கு there is a chance. But that should be decided only by the courts. நம்ம எல்லா இடத்துலயும் சொல்ல முடியாது. பட் இந்த 3 பேசிஸ்ல தான் அதை நம்ம வந்து டிஃபரன்ஷியேட் பண்ண முடியும். இது ஒண்ணுதான். அதே மாதிரி இந்த மின்டிங் கார்பரேஷன் ஒரு ஜட்மெண்ட் சொன்னீங்க. இட்ஸ் ஃபைன் ஜட்மெண்ட். பட் ஆனா அதுல லேட்டரா வந்து லாஸ்டா அந்த ஜட்மெண்ட்ல நீங்க வாட் யூ ட்ரை டு மீன் இஸ் அவங்களுக்கு இது கொடுங்கன்னு தான் ஆர்டர் வந்த மாதிரி எனக்கு ஞாபகம். அவங்களுக்கு ஓட்டி கொடுங்கன்னு சொன்ன மாதிரி தான்.
I will also check, sir.
ஏன்னா என்னோட டு மை மெமரி லாஸ்டா வந்து ஒரு திருப்பி ரெவியூ தான் நடந்ததுல ஓட்டி அவங்க வந்து என்ன சொன்னாங்க, அவங்க ஸ்டாஃப் கேட்டகரி, அவங்களுக்கு ஓட்டி நாட் எலிஜிபிள்னு சொன்னாங்க. பட் அவங்க ஏதோ ஒரு ஸ்பெசிபிக் ரீசனை சொல்லி நாங்களும் எக்ஸ்ட்ரா டைம் ஒர்க் பண்றோம். So being officers we have been forced to do work. என்னைக்காவது ஒரு நாள் பண்ணா பரவாயில்ல, always we are doing. So அந்த பெனிஃபிட் எங்களுக்கும் எக்ஸ்டெண்ட் பண்ணணும்னு they made a plea. And the High Court has also agreed that for the purposes of overtime they can be considered as workmen for only for the purposes of அப்படின்னு ஆர்டர் வந்ததா ஞாபகம். மேபி நீங்க இன்னொரு வாட்டி கூட பாருங்க. என்னன்னா டு மை மெமரி லாஸ்டா வந்த ஜட்மெண்ட் பார்த்ததா ஞாபகம். ஆனா பட் யூ ஹவ் given all fine examples on relating to all relevant topics.
Yes,
அது நீங்க நிறைய எஃபர்ட் போட்டிருக்கீங்க. நாங்க நார்மலா அட்வொகேட்ஸ் தான் அந்த வேலையை பண்ணுவோம். அது நீங்க பிராக்டிசிங் HR ப்ரொஃபஷனலா இருந்து you did so much effort.
Thank you, sir. Thank you, sir.
Nice of you. நல்ல செஷன். enriching session என்ன அப்போ இதுக்காகவே விடக்கூடாதுன்னா I want to join the session later also.
Please sir, please sir, please sir. Thank you sir.
சார் அவரும் அட்வொகேட் தான் சார், அவரும் அட்வொகேட் தான்.
வந்துட்டாரு பாத்தீங்களா, எங்கன்னு கேட்டா இல்ல நீங்க வந்துட்டாரு பாருங்க. கரெக்டா சார், அவர் அட்வொகேட் தெரியும் சார். ஆனா பிராக்டிஸ் பண்றவங்க போடுற எஃபர்ட் அவர் போட்டிருக்காருல்ல, அப்போ அதை நம்ம வந்து கண்டிப்பா வந்து அப்ரிஷியேட் பண்ணணும்ல. எங்களுக்கு இதே வேலை தான், நான் கூட கொஞ்சம் கம்மியா தான் ஒர்க் பண்ணுவேன். இதெல்லாம் ஒரு ரிலவென்ட் ஃபேக்ட்ஸ் சொல்லிட்டு கோட் சைடேஷன் மட்டும் கோட் பண்ணிடுவோம், அவ்வளவுதான். இவரு நிறைய ஹோம்ஒர்க் பண்ணியிருக்காருல, அப்ப கண்டிப்பா அது வந்து மோர் தேன் வாட் வி டூ இல்ல, அப்ப கண்டிப்பா அதை வந்து அப்ரிஷியேட் பண்ண மாதிரி.
Yes sir, yes sir.
Thank you sir.
Thank you sir, thank you sir. Any other queries or anything? Any queries or anything?
யாகு ஏதோ கேட்டாரு.
இல்ல கேட்கலீங்களே.
அவர் PhD சார், அவர் என்னையோட பெரிய ஆள் சார்.
அவர் கேளுங்கன்னு சொல்றாரு அவர்.
Okay sir, thank you sir. We will that's it. Another program sir.
Okay sir.
Thank you one and all. Thank you. I wish you a happy new year.
Happy New Year sir. Happy New Year to all.
Thank you sir.